Good day. I am Major Mark Paulo M. Melote, Judge Advocate General Service, and we are going to be discussing an introduction to military law and the Philippine military justice system. Colonel William Winthrop of the United States Army has discussed in his book, Military Law and Precedents, that military law in its ordinary and more restricted sense is the specific law governing the Army as a separate community. While Colonel Claro C. Gloria Jags, retired, the single most authoritative author of Philippine military law, reiterates what all soldiers know. Victory cannot be attained no matter how superior his forces may be in men and in materials, if discipline among the rank and file is found wanting. For this reason, in order to set an effective means of enforcing discipline, all organized armies of the world have promulgated sets of rules and regulations and later on, laws as embodied in an Articles of War, which defines the duties of military personnel and distinguish infractions of military law and impose appropriate punishments for violations thereof. Going back to Winthrop, he further describes military law as that law which, operative only in times of war or like emergency, regulates the relations of enemies and authorizes military, government, and martial law. Colonel Gloria, on the other hand, is more evolved and responsive to the times when he stated that military law is not established merely to enforce discipline in times of war. Rather, it also relates to the tranquility and security of the state in times of peace. For there is nothing more dangerous to the public peace than a licentious and undisciplined military body. For our overview, we shall be discussing the brief history of the development of military law, the concept of military justice, its components, the jurisdiction of military law, the AFP's investigative agencies, the distinct divisions of cases, some administrative measures available, the punitive measures available to COs, the court-martial and its procedures, and finally, we shall take a look at the punitive articles of war, or those specific acts punished under these articles. History points out the fact that nations have been engaged in wars. With this, bodies of men have been organized into armed forces under a commander-in-chief who enforces the highest form of discipline to ensure military efficiency. When it comes to examples of model armies, the Roman legionnaires most often than not tops the list. Clearly, many modern militaries evolved from or take inspiration from the ancient Romans. In the days of the Roman Empire, justice was usually administered by the magistri and by the legionary tribunes, either as sole judges or with the assistance of their consuls. Roman society at that time was a military society, and a single justice system served both the civilian and military needs. While among the early Germans, the administration of military justice was different in times of peace from that in time of war. In times of peace, the judicial proceedings were conducted by the counts, assisted by the assemblages of freemen, and in times of war, by a duke or a military chief who, however, usually delegated his jurisdiction to the priests who accompanied the army and carried its banners. It was not until a comparatively modern date that special courts were created to administer the German military codes. In France, courts martial were known to have been first established by an ordinance in 1655. Persons subject to the French military law had been subjugated to this jurisdiction, successively of the mayor of the palace, the grand seneschal, who is an officer in the household of a medieval prince or dignitary who then had full charge of the administration of justice, the constables, and then the provost-marshals. At this point in history, the laws have evolved where there is a clear distinction of laws that in the early 17th century, one Gustavus Adolphus, a king of Sweden, adopted a body of military law separate from the English common law to discipline his army. The Anglo-Norman system of administration of justice was quite close to the present American system. Under this system, the courts were open, the prosecution was public and verbal, and the accused was tried by a jury of his peers or military associates upon specific charges and was permitted to be heard in his defense. And the proof was made by the examination of witnesses. The Anglo-Norman system had extended to England, Sweden, and then Russia, and was generally adopted throughout Europe. The military courts then were established during the 16th and 17th centuries and were patterned after the Anglo-Norman system. And such courts, such as the present British and American court-martial, is more nearly assimilated in its procedures than to the present military court of France or any other court in Europe. Looking forward to the Philippines, we can safely say that the military justice system is older than our present codes and statutes. Historical notes amply show that the Revolutionary Army of 1896 established also a court-martial system to enforce discipline. While historical records do not disclose the system after which the Philippine Revolutionary Army court-martial was patterned, it may be presumed that it was adopted from the Spanish court-martial system, which at that time was obviously of European origin. Then before the Commonwealth of the Philippines was established, during the American regime, the Philippine Constabulary, which was also considered the only Philippine armed force then in existence, had its own court-martial system. A study of the American system of military justice is incomplete without glancing at the British Military Code. For nearly 2 centuries, it had been the forerunner of the parent code of the Military Code of the United States. The American Articles of War, although enacted by the United States Congress, can be described as definitely very British. The earlier British Articles of War were excessive in its severity. For almost every crime, the death penalty or loss of limb was imposed. Gradually, however, they manifested marked improvement until they assumed something of the shape in which the Articles of War in the modern times bear now. The British military law was brought into the New World when the Crown sent its royal troops. It exerted great influence over the early American colonies as manifested by the enactment of Articles of War for the government of their respective armies. In June of 1775, the first American Articles of War were enacted, copied largely from the British Code. This Code of 1775 did not remain in force for long, as the then U.S. Congress found it necessary to revise its laws. As I said, the Code of 1775 did not remain long in force, as this code was revised several times. And finally, in 1949, the Uniform Code of Military Justice was enacted to be uniformly applied to the Army, Navy, and the Air Force of the United States of America. Commonwealth Act No. 408, enacted by the National Assembly and approved on 14th of September 1938, with its amendments, is still the organic law of the Armed Forces of the Philippines. In implementation of Commonwealth Act No. 408 and pursuant to the authority vested in the President of the Commonwealth of the Philippines by Article 37 therefore, Executive Order number 178 dated December 17, 1938 was promulgated, and it prescribed the rules of procedure, including the modes of proof in cases before courts martial, courts of inquiry, military commissions, and other military tribunals in the Army of the Philippines. These rules were designated as the Manual for Courts Martial, or as the MCM. General concept. The military justice system in the Philippines is designed to enforce discipline and administer justice in the armed forces of the Philippines. This consists of rules governing the conduct of military personnel and providing a method by which persons who break those rules may be punished. This is designed to enforce discipline and administer justice in the military service. This system is composed of four components, namely investigation, prosecution, trial or adjudication, and judgment or decision. And these components pervade two distinct divisions of the justice system, namely administrative and punitive cases. What are the sources of military law? First, we have the Philippine Constitution, Commonwealth Act No. 408 as amended, or more popularly known as the Articles of War, Commonwealth Act No. 1, or the National Defense Act, Revised Administrative Code, or EO 292, executive orders, proclamations, administrative orders, and military orders issued by the President as Commander-in-Chief of the AFP, legislation by Congress and the Senate, judicial, administrative, and quasi-judicial bodies, and its decisions and their interpretations. Of course, AFP regulations and general orders, and the digest and opinions of the Judge Advocate General, AFP. We have here the components of the military justice system. Investigation is the process of looking into the circumstances of a case for the purpose of verifying and establishing the facts. It also involves the gathering, handling, the protection, and preservation of evidence to prevent its destruction, loss, or tampering. Prosecution occurs after the determination of probable cause or prima facie evidence to support reasonable grounds that the respondent has indeed committed an offense, and referral to the General Courts Martial or Efficiency and Separation Board is warranted. As for trial and adjudication, this is where evidence may be received against or in behalf of the respondent, and it is where the latter's opportunity and right to be heard after being informed of the charges against him is availed of. And lastly, judgment or decision is the adjudication by the court or a board exercising quasi-judicial powers that the accused or respondent is guilty or not guilty of the offense charged after receiving and deciding on all available pieces of evidence presented. A fifth component may be added, and that is appellate review and confirmation. Once the process of trial is complete, the records are transmitted to the convening authority for appellate review. Then after the decision in this review stage is evaluated further for implementation or execution of the decision. This is logical, being that a court-martial's judgment is simply recommendatory. It is not being operative until approved by the convening commander or authority. Who are persons subject to military law? Articles of War 2 provides the following. All officers and soldiers in the active service of the AFP, members of the reserve force from the dates of their call to active duty and while on said active duty, trainees undergoing military instruction, all other persons lawfully called, drafted, or ordered into or to duty for training in the service from the dates of their call, draft, or order to obey the same, cadets, flying cadets, and probationary second lieutenants, retainers of the camp, and all persons accompanying or serving the AFP in the field in times of war or under martial law if declared. and all other persons under sentence adjudged by court-martial. As a general rule, a court-martial has no jurisdiction to try a soldier for an offense committed prior to his entry into the military service. There are exceptions, though, such as fraudulent enlistment under Articles of War 54. While separation from service generally terminates the jurisdiction, except to certain offenses of fraud and embezzlement as found in Articles of War 95. We mainly have 4 investigative agencies under our current military justice system. The Office of the Inspector General. This office mainly has jurisdiction over matters pertaining to mission accomplishment, effectiveness, utilization of resources, states of discipline, operational readiness, security test and evaluation systems, and readiness of a unit. Also, on matters arising from inspections except those specifically provided as within the jurisdiction of the OESPA and the OTPMG. The Office of Ethical Standard and Public Accountability has jurisdiction over complaints and reports on violations of the Code of Conduct of Ethical Standards for Public Officials and Employees, or RA 6713, Anti-Graft and Corrupt Practices Act under RA 3019, Forfeiture of Unlawfully Acquired Property, RA 1379, violations of the Code of Conduct and Ethical Standards for Military Personnel in the AFP, crimes committed by public officers as defined in the Revised Penal Code, and other frauds against the government under Articles of War 95. While the Provost Marshal has jurisdiction over complaints and reports involving offenses against persons and properties, over cases involving violation of AFP policies and regulations on discipline, law, and order, and all other cases of misbehavior and misconduct in the AFP. And finally, for courts of inquiry, this is a fact-finding body or a board of investigation convened to pronounce a conclusion upon facts and is temporary in nature, composed of 3 or more officers. For the divisions of military justice, we have administrative cases and punitive cases. First, administrative cases are those that result in decisions not involving penal sanctions and may take such mild disciplinary or instructive forms of punishment such as admonitions, reprimand, etc. It merely requires substantial evidence as quantum of proof to support a finding of guilt. On the other hand, punitive cases result in judgment of fine, hard labor, deprivation of liberty, or combination of these whenever the guilt of those involved are proven by court-martial. The quantum of proof here is proof beyond reasonable doubt, since it partakes of a criminal character. For administrative measures, we have Section 105 of the Manual for Courts Martial, which prescribe for the procedures for implementing Articles of War 105, which we will discuss later. We also have EO 337, or that prescribing for the formation of the Efficiency and Separation Boards, to pass upon the retention or separation of officers due to inefficiency, gross misconduct, and immorality. RA 2334, whereby reserve officers in the active service for cause may be reverted or their service may not be extended beyond their designated tenure of call to active duty. Also, PD 1638, dated 10th of September 1979, which refers to the attrition or separation from the service for officers in the permanent grades of captain, majors, and lieutenant colonels. We also have Circular 17 GHQ-AFP dated 02 October 1987, which prescribes for two modes of discharge: honorable discharge for valid causes and dishonorable discharge under certain conditions which would warrant a separation without honor. We also have Articles of War 117, which provides for the dropping of officers from the rolls if such officer has been AWOL for 3 months, fully separating them from the service. Under punitive measures, this is largely under the regime of the courts-martial system and is the most familiar mode of dispensing with military justice. Republic Act No. 7055, dated April 30, 1991, transfers the jurisdiction to civil courts offenses committed considered not service-related. These refer to the offenses found in the Revised Penal Code, Special Penal Laws, and local penal ordinances, which in effect effectively repeals Articles of War 93 and Articles of War 94. Such acts include dueling, murder or rape, and various crimes punishable under the Revised Penal Code of the Philippines. Exceptional to the military justice system is the disciplinary powers of the commanding officer, found under the Articles of War 105 as amended by PD 1968. This is very characteristic of the regimented life of military men and women, as many minor infractions of the law, rules, or regulations occur from time to time in any command which requires some sort of punishment, but which are not sufficiently serious enough to warrant a referral to trial by court-martial. Thus, Articles of War 105 provide for a prompt and efficient method of disposing of such offenses without resulting to a full-blown trial. Only minor offenses upon persons under his command can be disposed of under this article, and whether an offense is minor or serious is a question of judgment of the commanding officer, who should consider, first, the nature of the offense, second, its effects on the organization, third, the manner in which such offenses are customarily punished, and fourth, the personal circumstances of the one who violated such law or regulation. The authorized punishments, aside from admonitions and reprimands, are withholding of privileges, restriction, arrest in quarters, forfeiture of pay and allowances, detention, deprivation of liberty, and similar punishments. For enlisted personnel, it includes confinement not under guard, hard labor, extra duties, correctional custody, and reduction of grade or demotion being the most severe under an authorized table of punishments. In the leading case of Olaguer versus Military Commission No. 4, no less than the Supreme Court held that military commissions or tribunals, by whatever name they are called, are not courts within the Philippine judicial system. As explained further by Justice T. Hankey in his separate dissenting opinion, the late Justice Black added that a court-martial is not yet an independent instrument of justice, but remains to be a significant degree a specialized part of the overall mechanism by which military discipline is preserved. As that, only ex-servicemen should be given the benefits of a civilian court trial when they are actually civilians. And finally, free countries of the world have tried to restrict military tribunals to the narrowest jurisdiction deemed absolutely essential to maintaining discipline among troops in the active service. These courts are composed of one or more members depending on the classification of the court, the function of which is to decide whether a person subject to military law has committed a violation of the Articles of War, and if it finds the accused guilty, to adjudge punishment for the offense. Therefore, it has the following characteristics. It is temporary in nature. It is an instrumentality of executive power. It is criminal in nature. It is a court of law and of justice. And finally, it is a court of honor. They are separated into the general, special, and summary courts martial, with the general court martial being the most prevalent and widely utilized court in the AFP. For the General Court Martial or GCM, it has the power to try any person subject to military law for any crime or offense made which are service-connected, punishable under the Articles of War. The contravening authorities extend from the President down to the division commander in the Army and his equivalent in the other major services. They consist of any number of members not less than 5, with one judge advocate officer as the law member. Special Courts Martial, on the other hand, has power to try any person subject to military law for any crime or offense not capital made punishable under the Articles of War. It is convened by any person who can appoint a general court martial, commanders of garrisons, forts, camp brigades, regiment, detached battalion, or squadron, and it is consisting of any number of not less than 3 members. And for the very rare summary court martial, which consists of only one officer, and the purpose of which is for dispensing justice promptly for very minor offenses under a simple form of procedure. Before a case shall be referred to the courts martial for a full-blown hearing, all cases against erring personnel who have committed service-related offenses has to be carefully studied. Thus, a pre-trial investigation is mandated to be undergone under Articles of War 71, which states that no charge will be referred to the General Court Martial for trial until after a thorough and impartial investigation thereof shall have been made. After the pre-trial investigation, the report of investigation shall then be completed and submitted to the appointing authority within 72 hours after the completion of such investigation. During that pre-trial investigation, the charges against the personnel shall be set forth so he can also prepare for his defenses. This is where substantial and procedural due processes under our laws are also accorded to the personnel, and the right of counsel is also ensured. Articles of War 38 prescribes that except for desertion, mutiny, or for war offenses, no person subject to military law shall be liable to be tried or punished by a court martial for any crime or offense committed more than 2 years before the arraignment of such person. As regards to violation of Articles of War 95, the prescriptive period is 3 years. After these said periods, one cannot be prosecuted anymore for the offenses committed, except for cases of continuing offenses or before courts of inquiries, and must be raised as a matter of defense. Otherwise, it shall be held to have been waived. As to other court-martial procedures, we have the first stages or the preliminary stages, the assembling, the swearing in of reporters and interpreters, the announcement of the names of the members, challenges made by the trial judge advocates or the prosecutors and by the military defense counsels and the accused, if any, and swearing of the members of the court and the personnel of the prosecution. The second stage consists usually of the trial proper, consisting of the arraignment of the accused, followed by the presentation of the evidence by the prosecution, then the presentation of the evidence by the defense, and arguments made, if any, by both parties. The third stage is the deliberation and voting by the court on the findings and agreeing on the sentence. The post-trial stages of proceedings consist mainly of the appellate stages. And this is where the review made by the staff judge advocate is done. As shown and listed are the punitive articles of war, which mainly contains the acts which are service-connected and are prescribed for their punishments. The usual articles violated are Articles of War 54, 59, 62, 63, 64, 65. For this set of lists, Articles of War 84 and 85 seem to be the more popular violations. And finally, we have Articles of War 95, Frauds against the Government, Articles of War 96, Conduct Unbecoming an Officer and Gentleman, which is exclusive to officers. And finally, we have Articles of War 97, the General Article, which is a catch-all provision that punishes all acts which, detrimental to the military service, are not described specifically in the other Articles of War. And that finally ends my presentation. Thank you and good day.